Senate Bill 250 is the Tennessee Firearms Freedom Act. Many of you may remember that in 2009 we passed the Tennessee Firearms Freedom Act that had to do with guns, accessories, and ammunition that was made in the state of Tennessee, that was stamped made in Tennessee, that the federal government had no say as long as it remained in the borders of the state of Tennessee. It is interstate commerce to be regulated by Tennessee. This bill is an amendment to the Tennessee Firearms Freedom Act. The bill goes on to define federal action, any action of Congress, the federal executive branch, or the federal judicial branch that would have the force or effect of law over the citizens of this state, including but not limited to acts of Congress, federal rules or regulations, executive orders, and judicial opinions. It then adds new code sections to the existing Firearms Freedom Act to say that the General Assembly declares that any federal action prohibited by this chapter relating to firearms, accessories, or ammunition, whether made in Tennessee or not, is not authorized by the United States Constitution and violates the restrictions contained therein. It is hereby declared to be invalid in this state. It goes on to give law enforcement the ability to arrest someone who tries to enforce this unconstitutional law, makes it a Class B felony, and it also says that the Attorney General will enforce this law. If he refuses to enforce it, we can hire special counsel to enforce it. Any citizen could go to the courts and ask to be heard on this. Now, there have been comments about whether or not we can do this under the Supremacy Clause of the United States. The Supremacy Clause only applies to those federal laws which are enacted that are clearly within the scope of the authority of Congress. The phrase in Article 6, which imposes the limit, is the phrase, which shall be made in pursuance thereof, which means that only those federal laws enacted pursuant to the Constitution are supreme. Those enacted in violation of the Constitution would be unconstitutional and would not be subject to the Supremacy Clause. Many would assert that anything done by Congress is supreme merely because Congress did it. However, there are many instances where the Supreme Court has declared federal action to be unconstitutional and therefore prohibited by the Constitution. Through 2010, the Supreme Court has expressly invalidated federal laws on at least 165 instances. An unconstitutional act is not a law, but itself is a violation of the Constitution. It is illegal, void, and unauthoritative. Therefore, it cannot stand supreme. The mere fact that the federal government does something does not confer supremacy. To be valid, any federal action must find roots in the enumerated powers delegated in the Constitution and not violate the Bill of Rights, specifically the 10th Amendment. 16 Amjur 2nd, Section 177, late 2nd, Section 256 says, since an unconstitutional law is void, the general principles follow that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. Alexander Hamilton put it succinctly in Federalist 78. There is no position which depends on clearer principles than delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. Senate Bill 250 makes it a state crime to seek to enforce unconstitutional federal laws. Since the Supreme Court has held repeatedly that unconstitutional federal laws have no protection under the Supremacy Clause is not a legitimate issue. It addresses only constitutionally permissible federal laws. Senate Bill 250 only addresses unconstitutional void federal laws. So there can be no conflict. So who decides? Some would say the Supreme Court, and it could. However, as Thomas and Jefferson noted, the Supreme Court is not the only decision maker. In addition, the states have authority as to this issue under the 10th Amendment and the constitutional doctrine of nullification. Nullification begins with a decision made in the state legislature to resist a federal law deemed to be unconstitutional. It usually involves passing a law. In some cases, it might be approved by the voters in a referendum. It could change the state's statutory law, or it might even amend the state constitution. It is a refusal on the part of a state government to cooperate with or enforce any federal law it deems as a sovereign to be unconstitutional. Nullification carries with it the force of state law. It cannot be repealed by Congress without amending the U.S. Constitution. It cannot be abolished by an executive order. It cannot be overruled by the Supreme Court. It is the people of a state asserting their constitutional rights by acting as a political society in their highest sovereign capacity. It is the constitutional remedy for unconstitutional federal laws. So with that, Mr. Chairman, we do have one person who has asked to testify, June Griffith from the Tennessee Commission for the Bill of Rights.
Okay.